My name is Alex Njeru. I work within Eastern Africa Policy Center as the Programs Director. Today we are having a conversation with Martin Van Staden from South Africa. Martin Van Staden is a legal researcher with the Free Market Foundation in South Africa. Welcome, Martin. Nairobi.
Thanks for having me, Alex. It's great to be here.
Thank you. Karibu Nairobi, as we say. Martin, as a lawyer or as a professional interested in the law in South Africa, how would you describe the philosophy of law in South Africa?
So South Africa has a very rich legal tradition. We have the Roman Dutch law and English, British common law. So the British common law brought us the natural law theories about individual rights and so forth. But from our more conservative Roman Dutch lawyers, we always had the positivist mindset that whatever government says in the law basically should be allowed. So that was the debate under apartheid, positivism versus natural law. So since apartheid has ended, we have in our constitution, or implicitly in our constitution, called something called transformation. So this is to take South Africa from a apartheid society to a post-apartheid, prosperous, free society. Although transformation now seemingly means more government rather than more individual rights. So unfortunately our legal philosophy is very confused in many ways. My honors thesis essentially was on this. Basically that South Africa's legal philosophy fundamentally still believes in social engineering rather than the American dominant legal philosophy that there should be a framework built around the individual and his rights to pursue his own destiny. In South Africa, unfortunately, we're following a program of government, and that's our philosophy, unfortunately, for the most part.
It's a new sort of description of the philosophy, the legal philosophy in South Africa, largely referred to traditions, the common law traditions in Roman Dutch law. I mean, it's South Africa being an African country. Does it draw its philosophy from sort of African-oriented philosophy in a sense?
Well, so they say. So our past legal tradition was almost entirely European, so it's the Roman law infused with Dutch law, and then the British law came later on. But we always had African customary law in South Africa to more or less extent, and the apartheid government to a very small extent recognized African customary law. So with the end of apartheid, that came into our constitution, where the constitution officially said that African customary law will be recognized as an official part of our law. And so our constitution is described as post-liberal, so it's not necessarily just a Western liberal democracy constitution. It's infused with a lot of competing ideas, and it seems like African customary law is now sort of infused into our philosophy of transformation. Although that remains to be seen. It seemed to me, as a libertarian observer, it seems to me to be ordinary European welfare statism that is being confused for African customary law. So yes, I would say that officially we have some African customary influences, although it's being used just as a mask for more government intervention, and I'm not sure that is necessarily what African law implies.
So it's the Supreme Court of Appeal a couple of days ago made a decision that corruption charges against the president be resuscitated. What does this mean for the rule of law in South Africa?
Well, so on paper it seems like the rule of law is alive and well, and a very positive part of our constitution and a very unique part of our constitution is in section 1C, which says that South Africa is a democratic state founded on the supremacy of the constitution and the rule of law. So that's something that people often miss when they read our constitution. The rule of law is the supreme law of South Africa, which is very unique, and as a libertarian myself, it seems like a very good part of the constitution, which is often underemphasized. So this SCA judgment against Zuma shows that the president is constrained by law. You can't just order his henchmen to drop the charges and then he'll get away with that. Unfortunately, as I wrote an article about this right after the judgment, I said that charges should not be brought against Zuma because he still controls the prosecuting authority. And that means that if he is charged now, the prosecuting authority will either provide a very bad case against him, or they will appoint a bad lawyer to make the case against him, and then the court will have no choice but to find him innocent, and then the principle of double jeopardy will protect him from being prosecuted again. So my suggestion is that, the Supreme Court of Appeal didn't give a timeline on when he should be charged. They just said that the withdrawal of charges was irrational in the first place. So I'm encouraging the Democratic Alliance, our opposition party, and NGOs to exercise some caution and restraint, to rather pursue Zuma on these charges when a different government, or at least a different president, is in power, because at this stage it doesn't make any sense.
Okay. So South Africa has sort of a demarcation between institutions. You have an office called the Public Protector, for example. How is there like a power play or like conflicts of interest between these distinct institutions, parliament, the judiciary, offices like the public protector, who I would think would be the ombudsman, the Kenya's case?
So, not as much as I would like. So, in the United States, there is always a tug of war between the president, Congress, and the Supreme Court. Everyone wants to essentially say that I'm the big boy on the block, and that's good. That's very good when they jealously guard their own domain and try to limit the other branches of government, whether that's in their self-interest or for some common good or for liberty. It doesn't matter. It's good that government is essentially at war with itself all the time. In South Africa, that is not the case. Our constitution talks about cooperative governance. So that means that, yes, there is a separation of powers between the executive, the judiciary, and the legislature, but at the end of the day, everyone must work together in harmony and get along and align to the same principles and the same objectives, which is very dangerous. But yeah, so sometimes we do have this conflict. So our previous public protector, Thuli Madonsela, she was a very surprisingly moral and person with a lot of integrity, and she stood up to the executive government a lot. When there was corruption, she dealt with it, and she dealt with the president in a way he used taxpayer money to build his palace in Kandla. So she found against him and said, yeah, he needs to pay that money back, or at least some of it. So that was only with Thuli Madonsela, unfortunately. Previous public protectors and the current public protector, these people always seem to be kinda in the president's camp, and they're not really too controversial. They're not balancing power. But yeah, other than that, we have the Auditor General, and these are all formally independent institutions, and the Independent Electoral Commission. They're all formally independent, and sometimes there's some tension, but at the end of the day, it's nothing of consequence when you look at it from an individual rights perspective. At the end of the day, all the institutions of government still believe that the individual's rights need to be limited in pursuit of some abstract greater good, unfortunately.
Previously you had inquired about the role the public prosecutor or the public protector played in sort of protecting public interest, with particular regards to the state of state capture in South Africa. So do you have institutional mechanisms in South Africa that hedge against state capture and cronyism, all these aversions of governance?
On paper, yes. So we have the Auditor General, which is an independent institution, and for the most part I seem pretty, had a lot of integrity and so forth, to ensure that funds are being used judiciously and so on, and not used for corruption. And the Public Protector, of course, which you mentioned, is an ombudsperson, which looks at complaints against government and especially tries to combat corruption in government. Then, of course, we have the judiciary, which must enforce the law against corruption, against government, if it is so corrupt. Then we have a lot of anti-corruption police task forces and all these things. And yes, especially our prosecuting authority, the National Prosecuting Authority, is by the Constitution compelled to be impartial and apply the law without fear, favor, or prejudice. Now, all of this is great on paper. This is not what happens in reality. So state capture has been popularized in South Africa, and the institutions have not been successful in constraining it. Unfortunately, because the Constitution, it would seem, was written specifically for Nelson Mandela. So he was this great person with a lot of integrity, and he was around when the Constitution was drafted. And it seems like everyone had in their mind this image of the South African president always going to be like Nelson Mandela, someone who is very averse to corruption, someone with always good intentions. That was not the case, and they should have known better. So unfortunately, our Constitution does give the president quite broad powers, including appointing people to the superior courts, appointing the public protector, which is it completely defeats the purpose of the public protector, and appointing other key officials who are supposed to stand against corruption. So yes, on paper we have a great framework to guard against corruption, state capture, nepotism, and so forth. Unfortunately, in practice, the president has too much power, so if the president himself is part of the corruption, most of these things on paper fall away as being somewhat irrelevant.
It has been a pleasure speaking to you. Finally, what is there to look up to in South Africa in the next couple of years?
So what's interesting now in South Africa is we have the African National Congress's policy conference at the end of 2017. Quite exciting. We're going to see who's going to be the next leader of the ANC, which is always a relevant race to watch. And then, of course, we have the general election in 2019, which is a very exciting election as well. We're wondering whether the ANC, for the first time since apartheid ended, will fall below 50% of the vote, and if not, whether our economic hub, which is the Gauteng province, which includes the national executive capital, Pretoria, and Johannesburg, the largest economy in Africa, we're thinking that maybe Gauteng will fall to the official opposition, which would change the ballgame in South Africa substantially. So these are all very exciting things happening in South Africa. We're all keeping an eye on it. And luckily our courts have survived. It's a very strong institution. So it's not, and our Reserve Bank, I should say, it's quite a strong institution. In Zimbabwe and in Venezuela, the Reserve Banks have been captured, and they've destroyed the economy essentially by printing more money. So there is still a lot of hope in South Africa. Our economy won't crash because of printing and inflation, and our courts still seem pretty strong in arresting government corruption, at least so that it doesn't become a way of life that's accepted. So there's still outrage against corruption, and the courts enforce that pretty well. So yes, a lot of things to look up to. The election is very exciting, maybe a game changer in South African history.
Thank you very much, Martin.
Thanks, Alex. It's been a pleasure.
It's been a pleasure having you. We were having a conversation with Martin Van Staden, legal researcher at the Free Market Foundation in South Africa. We sort of broke it down to what we expect and what the germane issues, especially with regards to rule of law in South Africa, are. Thank you very much.